Professor, thanks so much for taking the time to do this.
Thank you.
The whole thing.
Okay.
Now, Professor, many years ago in 2000, you wrote an article entitled Property Rights and the Human Body, in which you explored the property rights that one has in him or herself in tort litigation, as well as the property rights one has in others for the purposes of tort litigation. Can you discuss that a bit?
Yes. Well, I suppose I was motivated by where the law stands today on property rights in the human body. And we just had a scandal connected to that just a few days ago because there's a person who's at Harvard Medical School who was selling the body parts of bodies that were given to Harvard Medical School for research. So, and then there are underground markets for body parts as well. I mean, organs and tissue and body parts. And what's happening is that because of technology and the improvement in transplantation technology, body parts are worth a lot of money now. They're quite valuable. You can save lives with body parts. And of course, if people die with healthy organs and the body just goes into the ground, that can be maybe $500,000 or $1 million worth of body parts that are just thrown into the ground. So that creates this enormous possibility of a black market out there that you have to assume, given human ingenuity, people are trying to find ways to exploit. So that raises questions about what we can do. And one of the things that we should consider is, of course, recognizing those rights that people have to their own body parts, allowing within limits people to be able to enter into contracts in which they essentially sell those body parts, give someone else a right to them. That would hopefully go some way toward reducing the black market that presumably exists already. I don't know anything about the black market myself, but presumably does exist, since we just had this scandal at Harvard Medical School just a few days ago involving the sale of body parts. So we could do something to reduce the scale of this black market. We could also make more organs available for transplantation. That would reduce the number of people who are sitting on waiting lists to receive organs and dying while they're sitting on waiting lists. And I think there's a lot to be said for moving that direction. And of course, one of the problems is you have medical ethicists who are basically arguing against any kind of contracts for the sale of body parts, which results paradoxically in the existence of the black market instead of having an ethical result. The result of these ethical arguments is to produce an unethical result, which often is the paradox that sometimes people don't realize it happens. But so that's what motivated me to write, on these questions about body parts and markets. But tort law already recognizes some limited property in a person's body. Of course, if you're injured, you suffer bodily injury. Of course, you can receive damages. And if the body of a close relative is harmed or treated badly, that's treated as a quasi property right of those survivors, and they can sue for damages. But I guess what I was writing about, first of all, in that piece that you're referring to, I was just trying to lay out the law as it exists on property rights in the body, but also is part of a larger project in which I argued that we ought to recognize broader property rights in the body for certain utilitarian reasons.
Now, the concern is to limit black market sale.
Mm-hmm.
And is criminalization not sufficient? Certainly, these activities are criminalized. You can go to
Yes.
jail, right, for these things. Is that, as your research has shown, insufficient to remedy the issue?
Well, I think it is insufficient, and I would cite the example of Harvard Medical School only a few days ago. I mean, okay, so if some person who's got a position at Harvard Medical School is selling body parts, then you'd have to imagine it's happening in other places as well. So no, I don't think the criminalization has been sufficient. And I think, and you could imagine an analogy. You could say, well, suppose you get rid of tort rights to all individuals. They didn't have any right to sue for bodily injury, but only the state brings criminal claims. In that case, well, you can see the problem that would arise, because the state wouldn't always be as diligent as it should be in enforcing those laws. And so people would be injured and they wouldn't have a right to bring suit. To some extent, it's the same way, you could say with the body parts issue with and property rights and body parts, that right now it's the state that goes after the black market in body parts. But maybe it'd be a different thing if individuals had rights to those body parts, had enforceable claims to those body parts, had enforceable rights to sue for those claims, and of course, people who felt they had an interest in entering the black market, such as the person who was just arrested at Harvard Medical School, might find that they could satisfy their own interests or their own interest in a market legitimately just by entering into the market for transplantable organs directly.
Professor, I'd like to shift a bit towards antitrust law.
Sure.
Written a ton about. As a general matter, broadly speaking, is antitrust law anti-capitalistic?
That's a good question. I couldn't say yes. I mean, antitrust law, of the proponents of antitrust law, some are anti-capitalistic, some are not. So I can't say that in general antitrust law is anti-capitalistic. I suppose you could take a strong position. You could take a strong position that says it's anti-capitalistic because under the fullest recognition of property rights and in an effort to incentivize the benefits of capitalism, you could say, well, there should be no antitrust law at all, because let's take Section 1 of the Sherman Act that prohibits price fixing. Well, you could say, well, that's just a property rights question. If I own widgets, if I'm selling widgets and the guy next door is selling widgets, those are our widgets. And of course we can enter a contract that says that we're going to fix the price of widgets. They're our property. We can decide how to allocate our property. And what's the government doing telling us that we can't fix prices? That's one view of Sherman Act Section 1. And then Section 2 is the part that prohibits monopolization. And you could say to that, well, what's monopolization? Well, monopolization is just taking your assets and using them, leveraging to the best of your ability to gain a greater market share. And you could say, well, that's what business is all about. Where did you come from? That's what every business is trying to do. So you could say on that basis that the whole Sherman Act is anti-capitalistic. On the other hand, I think that's an extreme position. The common law took a fairly subtle position toward price fixings. The common law position toward price fixing was, you can enter into price fixing agreements, but don't look to the courts to enforce those agreements. So those agreements, if you want them to be enforced, you just have to hope that they'll be enforced. And if you go to court, the courts have to review those agreements and see, whether the agreement has a legitimate basis or whether it seems to be purely an effort to take advantage of consumers, of the public, in which case the court would not enforce the agreement. So that's the position the common law took toward price fixing. The Sherman Act takes that a step further and says, well, not only is this unenforced, not only are these agreements unenforceable, but they're criminal as well. Okay. So you could say, well, maybe that's not that big of a difference. Under the common law regime, you can't enforce these agreements under the Sherman Act. You can't enforce them, and they're criminal as well. On the other hand, a different position you could take is that is a big difference, and we should be concerned about that. But I guess I'll say those strike me as at the first level empirical questions. On a deeper level, they may be ethical questions as well, and I can explore that. I'm happy to explore that. It would take maybe a few more minutes in this answer. I don't know if you're willing to grant me those few extra minutes, but you say go for it.
Mm.
Okay, so here's the ethical question as well. So what is price fixing? Price fixing is, I've got my widgets, you've got your widgets. We entered an agreement that we're going to fix the price of widgets. Who is that hurting? Well, the consumer is paying more for widgets, but the consumer wants the widgets anyway. So the consumer is just not getting the best deal that he could have gotten on widgets. Well, that's something that happens all the time in life. I mean, you don't always get the best deal, and there are all sorts of quote unquote markets where there's not a competitive structure. So there's a theory behind the prohibition of price fixing that you as the consumer have a right to a competitive structure in the market where that structure appears to exist, naturally. But that doesn't appear in nature in any sense. I mean, we don't see competitive markets overall. If you enter into the marriage market, it's not a competitive market. You're often stuck with who you have, and that's it. You're not comparing options. You're not saying I could go with this one, or I could go with that one. So there's so many real world choice questions where the competitive assumption does not exist. And so you could ask as a question of ethics, why should we think that the competitive background is default that should exist in any market at all? And why should we therefore say that the consumer has a right protected by the criminal laws to a competitive market? To me, that's a question that's worthy of debate, and we've adopted that assumption in our Sherman Act and therefore in our criminal law as well. But again, it's not clear to me that these are obvious. These are questions with obvious answers, and so it's not clear to me that I would go so far as to say the Sherman Act is anti-capitalistic. It does represent, I think, an important innovation in the law in America. I think before the Sherman Act, there were presumptions about what could happen in the market that were changed by the Sherman Act, and the adoption of the Sherman Act has sort of worked itself gradually into not only from becoming a change, an innovation on the operating legal framework, which was viewed as sort of novel, but now becoming sort of the default framework adopted by the court. So, for example, when the Supreme Court looks at the intellectual property laws now, it often adopts a default position instructed by the Sherman Act, which is, in my view, totally bizarre, because the intellectual property laws were designed to grant limited monopolies, in a sense. And monopoly may not be the right term, but property rights and ideas, which in some cases could be effectively monopolies, and they weren't supposed to be touched by the Sherman Act at all. But now it's not uncommon for courts to adopt the Sherman Act as a default position when examining the intellectual property laws, which strikes me to be a very serious mistake that courts have made and continue to make. And maybe I don't know what this will lead to as time continues.
A few years ago, you wrote an article entitled "Digital Platforms and Antitrust Law."
Yes.
The How has the evolution of digital platforms, of social media, impacted antitrust law and intellectual property law, which you touched upon a second ago?
Right. Well, so far, not much. I mean, there have been the digital platforms and the dominance of some of these firms has led to a lot of discussion in Congress, and so there have been many discussions by legislators to enact amendments to the antitrust laws or new versions, new types of antitrust to govern the tech sector. And I don't think any of these proposals has made it into law so far. I am, but the efforts continue, and if you pay attention and if you watch the the legislative discussions and hearings in the Senate, it's not uncommon to see a lot of discussion about reforming the antitrust laws. And luckily, it's easy to keep track nowadays because so many of these senators are posting videos of their discussions on YouTube, so you can find a lot of these debates and discussions, videotaped on YouTube, which, by the way, is pretty entertaining stuff. If you have nothing to do, watching those videos can often be both educational and entertaining. But anyway, back to the subject of the discussion. So that so far there hasn't been much of an impact by these of the dominance of important platforms in the tech sector on the antitrust laws. Not much of an influence. There's an effort as a result of this to reform the antitrust laws, which hasn't happened yet. I feel myself the antitrust laws are so flexible that the case for reform seems very weak to me, because the Sherman Act itself is an extremely short statute, the most important part. In fact, you can summarize the Sherman Act in 5 words. So the first 3 words are "don't fix prices." That's section 1. Second is "don't monopolize." That's it. That's the Sherman Act, 5 words. Now that leaves infinite space for the courts to innovate around those terms. And so you can bring any new technological development to the courts and say, this is an antitrust violation. And there's nothing that prevents the courts from adopting the law to deal with that problem in front of them, because the law is so sparse, it can be applied to any kind of area, any kind of technological venture, whatever. There's nothing that prevents the courts from innovating. So I don't see the argument for amending or changing the Sherman Act because we have a new tech sector strikes me as totally unpersuasive. But anyway, that's the argument that's often made, and it's led to a lot of effort in both in state legislatures. Actually, a lot of it's in state legislatures now, and in the federal legislature. As far as the tech sector itself, yes, that's true that we have dominant firms, and some of the activity they engage in has led to complaints, and some of these complaints are legitimate complaints. I don't see a reason why the antitrust laws aren't capable of dealing with those complaints as they exist right now. I do feel that the dominance of a lot of these platforms is probably a short-run or temporary phenomenon that will change over time as new innovation occurs, as competitors enter into the market. So back 100 years ago when the Sherman Act was passed, it was the railroads that were dominant firms, and people felt the railroads were abusing everyone. And now I don't think anyone views the railroads as abusive dominant firms anymore. Now you could say, well, that's 100 years. Why should we wait 100 years for things to change? But I think that I don't think the Sherman Act had any impact itself on the structure of the railroad industry. And in fact, to the extent the Sherman Act was having any impact on the behavior of the railroad industry, the railroad industry quickly fixed it by setting up a regulatory framework under the Interstate Commerce Commission that allowed it to continue to do what it was being prohibited from doing under the Sherman Act. So I think the same threat would arise in the tech sector. So if the courts really began to change the conduct of the firms, the tech sector, they're powerful enough, I assume, that they would be able to lobby for a regulatory framework from the federal government that would allow them to continue to do what they do under a regulatory framework. And I think there's some signs that that's going on already.
Professor, you've also written about processes and legal concepts in the criminal law.
Yes.
An article entitled "Whom Should We Punish and How? Rational Incentives."
Right.
Criminal justice. Are we doing punishment the right way here in the United States?
Well, that's hard. It's a hard question to give a simple answer to, but I think in some ways no. In fact, one of the charts that sorry, just hit my camera accidentally. One of the charts that I have in that paper, which I find kind of interesting, just shows the increase in the incarceration of women in the U.S. over the past 30 years or so. And it's almost exponential growth if you look at it. And it raises a question, well, have women become so seriously criminalistic over the past 30 years that we're putting, multiples more in prison and in jails than we did 30 years ago? And I think the answer is no. I think we've got laws that ensnare many more of them than we had back then. And the correct purpose to me for imprisoning someone, for incarcerating someone, would be that they are a danger to others, that you don't want to let this person out on the streets because they're going to be harmful to other people. And that's true of basically, how should I say? I mean, that's probably true of maybe 1% of the women who are locked away. I mean, maybe 1% of them are dangerous to other people, and about 99% you can live, outside of prison, and then no problems would result. And so, in that sense, that's a clear example, in my view, of over-incarceration, excessive use of the criminal laws, and it's staring us right in the face. And there are huge social costs that result because these women can't, well, like the men, they can't engage in legitimate work, but unlike the men, they can't take care of their own children, or they can't engage in the activities that you say a mother could engage in if they're locked up in prison. So I think there are huge social costs from having our policies that have led to the incarceration of so many women. As far as the criminal laws go, I mean, it's sort of a complicated picture. I think the example I just gave is I think, in my view, Exhibit A for the case that we've been incarcerating too many people too quickly. Now, of course, when you get to men, the question is much more difficult, because now you do have a fair number of people who are dangerous to others. And so you have to be a little more careful about this over incarceration question when you get to men. One of the topics that I deal with in that paper is just the general expansion of the scope of the criminal laws. And I offer the Sherman Act as one example. Here's an area where we have the criminal law, and I actually confront that ethical question that I raised a few minutes ago, which is, is this an area where criminal punishment should be imposed at all? Is it a criminal matter if the consumer is denied a competitive framework by a bunch of sellers. And I think the case is probably, I mean, I think the answer is no, actually. And so I do argue in that paper that the Sherman Act is an example of of overexpansion. It's an old example, but it's because it's an old example, it's a good example of the overexpansion of the criminal laws, that you were injecting them into areas. And so I argue in that paper that there needs to be some scaling back of the scope of criminal laws, and that there should be a general presumption that market activities are not subject to the criminal laws, because market activities naturally involve a willing buyer and a willing seller. So that would say, for example, that prostitution should not be criminalized because it's a willing buyer and a willing seller. In a lot of cases of drugs, I suppose the same argument would go. I mean, certainly in the case of marijuana, the case for criminalization appears to be totally, unpersuasive. And of course, we've moved beyond that. The more difficult question is, what about other drugs? And I admit there might be cases where the external harms are so great that maybe you'd say, okay, we might have to maintain the criminal laws in this context. I think the presumption is that the criminal laws don't apply, and the operative rule would be if the external harm is extremely high, the criminal laws might be extended in those areas. And so if you had a drug, maybe fentanyl might be an exception. Maybe because fentanyl is said to be so deadly that you might make an exception for that because there isn't much of a possibility for someone to control its effects. But in the case where you have drugs that people use and they have some ability to decide rationally whether they're going to take them, and the drug doesn't necessarily immediately lead to death or destruction or to something like that, then I think I'd be more inclined to. I mean, what I argue for in the article is limiting the criminal laws to the harmful behavior and the harmful effects that result from those drugs, not from the drugs themselves. So, for example, if there's some particular drug someone takes that leads them to act irresponsibly and hurt others as a result, you would make them criminally punishable for the harm they do to others. And you could even enhance the penalties, in my view. You could even say, we'll give you more time in prison because you harmed others under the influence of the drugs you were taking or under the influence of alcohol. But they would not be punishable just for taking the drugs or just for consuming the alcohol or whatever. And it strikes me that's a more sensible approach to criminal enforcement in this area. Otherwise, what we're doing now, to get back to the example of body parts, we're encouraging black markets, and those black markets that are encouraged bring in people who are criminals. They enforce their agreements with violence, and of course that just contributes to the incidence of harm in society.
Seems that we claim to rehabilitate, right? The question is whether or not the policies in place actually move in that direction.
Well, I suppose some people are rehabilitated. I think the question is, and if it's the incarceration questions you're raising, I think the question is, again, is this person a danger to society? Because to me, that's the basis for holding someone. We don't hold someone because we think we can make you better, but if you're not a danger for society, there's no basis for holding the person against his or her will. And certainly the notion that we are going to make you a better person is not a basis for holding anyone at any time who's not a danger to society. By the way, this has a broad implication because we do so not only under the criminal laws, we do so under the basis of mental health, controls as well. So there are people being held in prisons in mental hospitals against their will on the theory that we're trying to help you, and some of these people are not dangerous to others. So my claim is that those people, if they're not a danger to others, they should be free to leave. They shouldn't be incarcerated. Now, of course, I do want to distinguish this from the homelessness problem because one of the effects of the incarceration that occurred earlier with respect to mental hospitals, people have said, is an increase in homelessness. I think the homelessness issue is a slightly different problem, and it should be dealt with in different ways. I think right now I'm just confining the discussion to criminal punishment and the holding of people for rehabilitation purposes, things like that. And so I would say that, again, the only basis for holding someone in prison or jail is that they're a threat, a danger to someone else. If they're not a danger to someone else, no, we don't hold them, and we don't even hold them if they're a danger. I would be actually somewhat reluctant to hold someone even if they're a danger to themselves. But let's say if there was solid evidence that they're a danger to themselves, if there had been evidence that they had attempted to commit suicide, maybe that's a basis for holding the person against his or her will. But if they're simply a danger, let's say some state psychotherapist looks at a criminal suspect and says, I think you're a danger to yourself. There's no clear evidence you're a danger to yourself, but I think you're a danger to yourself. That's not a basis for holding someone. That's, that ought to be actionable, and oppression. I don't know what legal claim it, but the people being held behind bars on the basis of those theories already, or right now as we speak.
Well, Professor, I really appreciate your time. Thank you so much.
Sure.
Very much appreciated once again.
Well, you're welcome, and thank you very much for this conversation.